This meeting is being recorded.
Hello, everybody. Thank you all for joining us. We're going to just wait just maybe a minute or so here to make sure everybody makes it in from the waiting room. And for anyone that does not know that this is a function that Zoom provides, we just learned this a few weeks ago ourselves. I have started the option for live captioning. So if you have a hard time hearing or just would like to be able to see the captioning, you should have a button at the bottom of your screen that allows you to request or turn on the closed captioning. So we are here today because we are wanting to do what we're calling a budget ratification refresher, basically walking you through the process that you need to follow in order to adopt assessments that your association attorney can collect. And both Ken and I have felt like it's really important for us to tell you, and we told folks this when we announced this class in our Q&A, that we're not here to tell you how you should be spending your money, that this is a good decision or that's a bad decision, you know, as far as the dollars and cents of your budget are concerned. Obviously, nobody can replace the board's judgment with the assistance of your manager, if you have one, in making decisions like that. What we're after and most concerned about is setting you up for success so that your procedure is correct and you don't have an attorney 6 months down the road tell you, oh, you didn't ratify your budget correctly, so we can't collect the increased assessments for this year, or you have to re-ratify the budget before we can do that. So that's our goal today. And I think we're ready to just jump in. But Ken, did you want to say anything before I start on the slideshow and the content?
No, you covered it. We're good.
Okay. And if you guys have questions, feel free to pop them into the chat. Just for the sake of time, I think that I'll go ahead and wait until the end to look at the questions in the chat. If you think something's really important to cover in the moment, if you could unmute yourself and ask it orally, that would be great, because I'm going to be sharing my screen, which puts my slideshow right in the middle of my screen, and I won't be able to see you guys or the chat while I'm doing this. So let's see if I can do this correctly. All right, can everybody see my screen? Yeah? Okay, great. All right, so as I said, we're here to talk about budget ratification refreshers, adopting assessments that your attorney can collect. And as we shared this morning, and we've talked about many times in our Q&A before, and also something that we say to our clients a lot, is that procedure is really important. Following correct procedure when you do things on behalf of your association is very important, because one of the most successful ways that owners challenge association actions is not by challenging the substance of the action itself, but by challenging the process, the flawed process that you followed in getting to that action. And so procedure matters. And closely related sort of bedfellow to that is that if it's not written down, it didn't happen. So whenever you're talking about anything that you do for your association, and ratifying your budget is no different, you want to make sure not just that you followed the correct procedure, but that you can document the fact that you followed the correct procedure. So the statute in question when it comes to budget ratification is RCW 6490-525, which is a section of the Washington Uniform Common Interest Ownership Act. Kiowa, I think Ken calls it Kiowa. So there are people who pronounce it differently. It's interchangeable, and it doesn't really matter how you pronounce it. This statute was adopted in 2018. It took effect on July 1st of 2018. And while most of it is not relevant to pre-existing associations, a handful of sections apply to everybody in Washington state, and the budget ratification section is one of them. This represented not a huge change for HOAs and new act condos, but it represented a significant change for old act condominiums, which had no statutory requirement for budget ratification and only had to actually ratify their budget through the ownership if that was required by their governing documents. So this is what the process and the timeline should look like. You need to adopt a proposed budget and then ratify it, obviously consistent with Kiowa, in order for your assessments to be collectible. And if you don't, your attorney can't take collection action to collect those assessments. So the board adopts the budget, and within 30 days you send notice to your owners of the proposed budget and of the budget ratification meeting. You have to give your owners no less than 14 and no more than 50 days notice of the ratification meeting. And your notice must be sent by mail unless you have owners who have opted in to receiving electronic notice. In that case, you can send it to those owners by email, but anyone who has not opted in to receiving electronic notice, you have to send it by regular mail. And there is a very specific list of information that the statute requires you to disclose to the owners in your budget ratification packets. And this is from subsection 2 of the Kiowa section on budget ratification. And that includes the date, time, and location of the ratification meeting, right? Because if people can't show up or get on the Zoom or call in the 800 number or whatever it is, they can't effectively participate. You need to send them a copy of the proposed budget. And this is sort of where we tend to see the biggest problems or the biggest defects in the budget ratification process. So the list of information that has to be included in that budget packet includes all of your projected income and expenses by category. This is nearly never an issue in the budget packets that we review. This one, you guys are, you're hitting the nail on the head with this one. It needs to include the amount of the assessments per unit or lot and the date on which they are due. So we almost always see a correct disclosure of the amount of the assessments per unit or lot, but we often see that nowhere in the budget packet does it say the assessments are due on the first of each month starting in January of 2023, or the assessments are due on the first of each quarter starting in January of 2023. So just somewhere, even if it's in your cover letter, include when the new assessment amount will go into effect and when those assessments are due. You also need to disclose the current amount of regular assessments that are budgeted for contribution to the reserve account, to the reserve fund. And this is a total budgeted amount that will be contributed to the reserve account. So it does not require a per unit or lot disclosure. Your budget packet must also include a statement of whether the association has a reserve study that complies with RCW 6490-550. So it needs to say the association has a reserve study that complies with that section, or the association does not have a reserve study that complies with Kiowa. And if you do have a reserve study that complies with the extent to which your budget meets recommendations of your reserve, along with how much your reserve study says you should be contributing to reserves this year. You also
Let me just add real quick there. You do not have to follow the recommendation of the reserve study professional. Your budget needs to say how much you're setting aside for reserves, and it needs to say how much the professional recommended you set aside.
That's right.
You don't have to comment or explain. You just have to include the two numbers.
Thank you, Ken. The other piece of information that you have to disclose is the current reserve surplus or deficiency expressed on a per unit or per lot basis. And the statute even tells you how to get to this number, because it says as calculated by RCW 6490-550. This is another one of the biggest mistakes that we see, and I'm going to be covering this briefly in just a few moments. We often, I think probably every standard reserve disclosure form that we have seen that was provided to our clients by one of the many reserve study companies in Washington, almost all of them include a reserve fund surplus or deficiency on an average basis. And if you're in a single family home HOA where the percentage allocations for common expense liability are all the same, then that's fine, because an average is the same as per unit or per lot. But if you're in a condominium association, for example, with a variety of different percentage allocations, then an average surplus or deficiency is not good enough to meet the requirements of the budget ratification disclosure requirements. So you can either ask your reserve study professional, if they provided you with an average, to give you a table that shows the reserve fund surplus or deficiency on a per unit basis, or you can calculate it yourself. You've most likely already got an Excel spreadsheet with all the different unit numbers on it and all the different percentage allocations so that you can disclose the amount of the assessments per unit. So you can just add one more column, take the total of the reserve fund surplus or deficiency and multiply that by the percentage allocations, and it gives you the information that you're required to disclose here. So those are all of the notice requirements in terms of what you have to disclose. There are a couple of notes though. One is that if you're in the middle of a multi-year special assessment, we would strongly recommend that you disclose and re-ratify that special assessment or the special assessment payments every year. We have clients who very frequently will adopt a 10 or 20-year special assessment that is installments paid over a really long period of time. And even though it might be argued that having ratified the whole special assessment one time in the very beginning was all that was required, I think there are a lot of reasons to re-ratify it each year. One is that you will have change in ownership over time, and some of your new owners will have no idea what the heck that special assessment is for. And so ratifying it each year keeps your current ownership informed. And more importantly, in my opinion, maybe not more importantly, equally as important, is the fact that if you have an owner who decides to take you to court to challenge the special assessment by saying, I never ratified the special assessment, I didn't even know it was happening, what the heck is going on? This was ratified 15 years ago and never mentioned again. If you're including it and ratifying it in each year's budget, it gives you a very strong defense to that type of claim. The good news, of course, is that once you prep the disclosures for that special assessment, they don't change very much from year to year. You just can update them going forward. So Ken, I feel like that's a good spot for me to stop and ask if you have any other comments you want to add with respect to the notices before I move on to the ratification meeting.
Well, I have a couple comments, and maybe they're out of order, but one is if you have an open meeting requirement for your community, like you're an HOA or a Ukiah community, the development of your budget should be done in open meetings also. And we have a lot of clients that don't want to do that. Our recommendation is still to do it in open meetings. It may actually reduce the number of questions that come up at the budget ratification meeting. The second is keep in mind the timeline on this. I was in a meeting with a client last night and they were trying to plan this out, and based on them holding the budget development meetings for their board and then having a board meeting to adopt it and then sending out notice to all the owners, they're basically looking at needing 6 to 8 weeks in order to make this happen, to allow the change in assessments to start on January 1st. And so that is something we want to make sure that people understand, is that you cannot accomplish what is required by the statute really in less than 3 weeks. And from a practical standpoint, if you start taking into consideration holidays, you're looking at 5-6 weeks. So you need to be thinking about this now so that you can have a budget to send out to all your owners in November and have a ratification meeting in December so that you can actually start your new year with the correct amount. We frequently have associations that start doing their ratifications meetings in January, and they want to start the assessments January 1st. And we have to tell them that they cannot increase the dues before the ratification meeting. Things have to be done in a specific order.
Thank you, Ken. All right, we're going to move on to the ratification meeting. And I'm going to start by saying you do have to hold a real-time meeting. You should not try to ratify your budget by email. And the meeting can be virtual or it can be in person. But we have had a number of folks ask us since last year's statutory changes, which codify the ability to vote by mail, whether you can ratify a budget by mail. And our answer to that question, at least at this point, is no, because number one, there is no case out there that offers the Court of Appeals opinion on whether this is possible or allowed under the statute. And number two, the budget ratification section itself very specifically calls for a meeting at which you ratify the budget. So until there's a court case that says otherwise, we think a court would interpret the statute to say that you have to have a budget ratification meeting, notwithstanding the ability to vote on other things by mail. The good news is that at the budget ratification meeting, you don't have to have a quorum, and more of our clients are shifting to holding the ratification meeting separately from the annual meeting, just because it streamlines things and it means you're not trying to track two different sets of standards for the two meetings. Because in order to do business at your annual meeting, you do have to have a quorum, but in order to ratify your budget, you don't. At the meeting, unless a majority of the voting power in the association as a whole, not just 50% or 51% of the owners present, but a majority of the voting power in the community as a whole, unless they vote to reject the budget, it is ratified. If there's no motion to reject, then the budget's ratified. If there is a motion to reject the budget, then the way to ask your owners to vote is to vote on whether they accept or reject the budget, rather than do you vote to ratify or reject the budget, yes or no, because that just gets way too confusing. And I was actually at a special assessment ratification meeting about 6 weeks ago where in a larger community where they started the voting that way, and they had to basically scrap the voting process halfway through and restart the whole thing because they missed this piece of advice about how to handle what is it you're asking the owners to vote. Accept or reject simplifies things and makes it clear. If the budget is rejected, you're not up a creek without a paddle. You do have a budget. You just revert to the last year's budget until you can ratify a new budget for the year in question. So a lot of times we'll hear people say, well, the budget wasn't ratified, so you can't charge me dues. That's not how it works. You do have a budget. It's just last year's budget until you can take another crack at the whatever and ratify the year in question. Ken, did you want to add anything before I keep moving?
I will. So basically what you're ratifying is the assessment amount that the owners are going to pay. You're not fixing in stone how the board is going to spend the money in the real world. Even though we're calling it a budget ratification, what you're doing is cementing the ability to assess a fixed amount for the month or the quarter or the year, and that's the amount which the owners have to pay. If your budget's rejected, the previous assessment just continues, and you adjust how you spend the money to take care of what you need to with the money you've got available. Because we have seen some clients that cannot get their new budgets and assessments approved, so they have to start adjusting how they spend money to match what their income is.
Thank you, Ken. All right. The next slide here just shows some notes that are related to this, but not specific to the subject of the ratification notices. One is that HOAs, single family plat communities that were formed under the HOA Act, which is RCW 6438, for those communities that have limits in their governing documents on the annual increases in assessments, Wakaiowa has invalidated those limits. So if you are an HOA formed under the HOA Act and your CC&Rs say you can't increase the dues more than 5% per year without the approval of your owners, and often there's a very high percentage approval required, that part of your CC&Rs is superseded, overruled by Wakaiowa. And the statute specifically says that this is a matter of public policy. In other words, the legislature, it was recognizing the difficulty that many HOAs were having in being able to adequately fund their obligations, and removed those restrictions by striking them in the Wakaiowa statute. This is not applicable to condominiums. So if you're a condo association that has some sort of limitation on how much you can increase the assessments each year, you don't get to benefit from this public policy decision that's codified in Wakaiowa. Another note that we want you to keep in mind is that you need to send payment coupons or some other notice to the owners regarding the outcome of the budget ratification meeting. Because if you don't tell owners that the budget was ratified and this is how much money that they owe as a result for this next year, they will have no way of knowing that. And I know that a lot of owners also just don't read their mail. Sometimes you send them notice and they still keep paying last year's amount. And that's why some of them end up in our office trying to get them caught up on their past due balance. But you need to be proactive about notifying the owners of the outcome of the meeting and the amount of the assessments for the coming year. Wakaiowa is silent on when you have to send that notice. And so then we default to it has to be reasonable, because that's the term and the standard by which all association actions are measured. I would say within 10 days of the meeting, and obviously as far in advance of the change or the new assessment obligation as possible. One of the things that Ken has said for a long time that I repeat a lot because I think it's great advice is that you should give your owners as much notice as possible of any increase. But in particular, when we're talking about something your owners are going to see as bad news, like a special assessment, you want to tell them as early and as often as you can about that coming down the pike, so to speak. So I'm going to talk a little bit about what to do when you don't have a reserve study, because if you remember the list of disclosures that you have to make, a lot of them are reserve study related. So there's a statement that's actually straight out of the statutes pertaining to resale certificates. And it's a statement you have to put in your resale certificate when you don't have a reserve study. That's the first paragraph on the slide that you're all seeing. And we think you should include both of these paragraphs in your your budget disclosures. If you don't have a reserve study at all, or if you don't have a current reserve study, or if your reserve study does not comply with Wakaiowa. So the association does not have a current reserve study. The lack of a current reserve study poses certain risks to you, the owner. Insufficient reserves may, under some circumstances, require you to pay on demand a special assessment, your share of common expenses for the cost of major maintenance, repair, or replacement of a common element. That's that language that's out of the statute that you put in the resale certificates when you don't have a reserve study. This next paragraph is perhaps more important, but certainly at least as important. And it goes on to say, because there is no reserve study that meets the requirements of RCW 6490-550, we cannot report how the budgeted reserve contribution deviates from the recommendations of a reserve study professional, and we cannot calculate the current deficiency or surplus in reserve funding on a per unit basis. So this is, I think, as comprehensive as it is possible to be, making it clear that you don't have a reserve study and that that's why you can't give them the information that's required by the budget ratification statute. And if you include this statement in your budget ratification packet that is sent to your owners before the meeting, and you do all the other things right, then we think your budget is enforceable and that we would be able to collect the assessments that result from that budget ratification process. Ken, did you want to add anything on that topic before we keep going?
No, but I'll back up one topic.
Okay.
It is possible for your individual CC&Rs or declaration to have a higher percentage required to reject the budget. Yeah. The statute allows it to be a higher percentage than 50%. And we do have clients where the community has adopted a 70 or 80% rejection requirement. And those are virtually impossible to meet. And that's why the boards adopted them when they started. But you do need to read your documents to see if it has a provision which is different than the statute, because the statute does allow a more restrictive rejection vote.
Thank you, Ken. So I know I briefly covered some of this as I was going through the ratification requirements, but these are the most common errors that we see. They include leaving out the date that the assessments are due, which is one of the things that I highlighted. They also include failing to disclose the reserve fund surplus or deficiency on a per unit basis. So remember, an average is not good enough. And the reserve study section of Wakaiowa actually tells you how to calculate the per unit reserve fund surplus or deficiency. Somebody tell me why we say surplus or deficiency. I don't think I've seen a single client with an actual surplus in their reserve fund, but I might be wrong.
About one out of 100 clients has a surplus.
Fine, so I'll keep saying it the way the statute says it. Other than these two mistakes, failing to include any piece of the information or having a flawed process. And the reason this is sort of a really general, like umbrella catch-all, is because we could be talking about you having sent your notices electronically when people didn't opt in. Maybe you didn't give 14 full days of notice. Maybe you forgot to include in the budget ratification notice the date, time, and location of the meeting. So there are any number of mistakes, and we're all human, mistakes can happen, that can invalidate procedurally the budget ratification process. The consequences of a flawed process are the possibility that an owner might successfully challenge the assessments. The association's attorney can't use the normal collections process to collect invalid assessments. So again, we might tell you, you have to re-ratify the budget, or that we have to collect the previous year's assessment amount. And so that might mean that you're left holding the bag on the difference. The good news here is that it's really, I'm going to say easy, simple. It's annoying and it's a burden, but it's relatively simple and straightforward to fix a flawed process. And you just do it over again the right way. And because you don't have to have a quorum, you can even say, if you're re-ratifying a budget that was somehow flawed the last time you did it, in your cover letter to the owner saying, we're re-ratifying our budget to satisfy our really picky attorneys. You don't even have to show up to this meeting if you don't want to. Nothing about the budget and nothing about the assessments are going to change. We're just dotting our I's and crossing our T's to make sure our process is accurate or correct. So even though the potential consequences to a improperly ratified budget can be significant, the good news is that although it's an administrative burden and a time requirement to re-ratify it, at least it's not a complicated process to do so. Ken, did you want to add anything?
Even if you end up ratifying it into the year, it can be done. So we've had clients where the challenge came halfway through the year. And so the people who already had been paying for 6 months at the rate, they could just continue paying at that rate the rest of the year. And the people who hadn't paid got to pay an extra large increase for the 6 months that they ratified the budget for, so that at the end of the year, everybody had the exact same payment obligation. It's a little bit more complex, but we can certainly help you do that. It's also, if you've got something like a reserve study and you're putting the disclosure and someone asks to see the reserve study, make sure you make it available to them. And if you disagree with the reserve study, still make it available to them. And if you want to put in a cover letter that your reason why you're not saving the amount recommended by the professional, you can do that, but there's no requirement to explain it, just as there's actually no requirement to explain your budget when it's presented to the owners. We see a lot of boards do cover letters that they'll explain that, cost of insurance is going up, or utilities, or, they'll try and help their members understand better the reasons why the budget is where it is. But those are not actually necessary parts of the process. So if you're just trying to be as simple as possible, stick with just what the list is in the statute in terms of the documents that you provide, and then wait for the meeting, and you can answer questions at that time if you want. But I've even had clients who basically had no agenda item other than, if a motion was made to reject the budget, they would vote. And they conducted the entire budget ratification meeting in a matter of 5 minutes. They based it on, the documents that they'd sent out. And if no one made a motion to reject the budget, they were done. In cases where less than 51% of the membership showed up for the meeting, sometimes they will simply say, because there are not enough votes present to reject the budget, even if every person present voted to reject it, then it's automatically ratified.
Thank you, Ken.
I would normally recommend you vote anyway, but that's not necessary if it's physically impossible for the rejection to occur.
Thank you, Ken. All right, we have some questions from the chat, and so we wanted to leave as much time as possible for questions in the chat. And Ken, I'm going to send this first one to you because number one, it's about reserve studies, which is obviously your wheelhouse. But number two, I'm going to make some slides, PDFs to drop into the chat so that anybody who wants to be able to look over the slides and take notes after the fact has the ability to do that. So here's the first question. Our reserve studies have 3 contribution requirements: fully funded, 70% funded, and baseline. So I'm assuming the question is here, how do we know which one is recommended?
Okay, so it should be that the reserve study professional picked a single contribution amount as their recommendation. They are required to calculate for you the fully funded and the baseline. And if they picked a threshold, that might be the one which they would consider to be their recommendation. If they have failed to provide a single recommendation, then what I would do is include all 3 to be particularly safe. But if you just put in one of them, I could support that the amount is still collectible by you simply stating which of the 3 that you're using. So if you stated the baseline funding contribution is $100,000 and we are only saving $50,000 for reserves in our budget, so the difference is $50,000, you will have satisfied the requirement for the budget process.
Thank you, Ken. All right, the next question was, are copies of the slides available? So yes, they are. I just dropped a PDF file into the chat that you should be able to click and it'll download it to your computer. If you're on a phone or you just can't do that right now, you can send an email to info@condolaw.net and we will email you a copy of the PDF with the slides on it.
We can do that if you're watching this on YouTube. Yes,
exactly. All right, next question. What happens if a special assessment is not ratified after the first year? You know, I'm just going to start with the things that I mentioned. One is that you may have owners who are like, what the heck is this special assessment? What's it for? I don't know what's going on here. But I think even more than current owner confusion is the prospect that an owner will, let's say they refuse to pay the assessments and you send the account to the association attorney and they don't pay, they don't set up a payment plan or respond when the lien is recorded. And perhaps there's a lawsuit filed, a foreclosure lawsuit filed. If the owner files a counterclaim and argues that the special assessment is invalid because the association failed to ratify it that year or any year that they are being asked to pay for, even if you ultimately win on that issue, your insurance is probably going to appoint defense counsel to defend you against those claims. That could result in your premiums increasing. And litigation is not a fast or easy or stress-free process. Even in the fastest cases, you are looking at something like 12 to 18 months before you even have a trial date. Most cases don't get that far, but in order to actually get a binding court decision saying that you didn't have to ratify the budget every year, the special assessment, excuse me, you would have to go to trial and then you'd have to appeal. So it's just a really long and onerous process if you have an owner who challenges the special assessment in court. And we would like to see all of our clients head that off by just re-ratifying that existing special assessment each year when they do their budget. Did you want to add anything on that one, Ken?
Yeah, I think that one way to approach it would be to simply attach the special assessment that was ratified before so that the membership understands that that is still ongoing. I'm not sure you would have to actually re-ratify it. My concern is that you will tell people they only have to pay $400 a month when they've got a $500 a month special assessment going. And their argument's going to be, I don't owe $900, I only owe $400 because that's what you sent to me as my payment contribution. And there is a statute that says that owners are allowed to rely on a representation by the association as to the amount of money owed. So I don't want there to be a mistake and it appear to an owner that they only owe this new budget and don't owe the remaining 14 years on their assessment that was ratified earlier. So that's one way. The second way to do it would be to actually understand that in most cases, fewer than half of the owners still owe that special assessment. And you can be pretty sure that it's the continuation of that special assessment for the owners who didn't pay in full will be ratified by all of the people who did pay in full. So I think that there's a way to work it out if you need some help in making sure that both the continuing special assessment and the new budget are both represented in your notice. We're happy to work with you to do it.
Yeah. All right, next question. What happens if a member says they never got the ballot in the mail? So I'm going to clarify here that it's not a ballot that you're sending. It's a budget ratification notice, including the packet that contains all the disclosures that we talked about. The association's obligation is to send the notice to all of the owners, and you have fulfilled that step of the budget ratification process and that requirement if you mail it to their last known address. If they've never told you what their address is, then you mail it to the unit. Or perhaps if you got an address notification from title when they bought the unit, whatever the case might be, you're not obligated to verify actual receipt. Can you even imagine the administrative burden that would represent? I can't. So your obligation is make sure you've got the correct address for somebody, use the unit or the lot address within the community if they haven't given you another one. Make sure there's a clear process or person that the owners in your community can contact with a request for an address change. But again, your obligation is just to send it. You don't have to verify that they received it.
Yeah, you do not need to give a ballot with the budget notice. You can require that a vote only occur if a motion is made to reject the budget at the meeting and it's seconded. And you can do a voice vote ballot at that time by simply calling a roll call of the people who are present, and they can say reject or accept the budget. If you're concerned, you do not send a ballot out in the mail because it might encourage people to actually reject the budget. And your goal is to ratify the budget, not to make it easier for a group of owners to send in ballots and reject it.
Agreed. All right, the next question. Can the board approve the draft budget via email? So if you're an association that has an open board meeting requirement, I'm going to say no on this. I think you need to have your budget discussion and approve your proposed budget in a meeting, in an open meeting. Even if you don't have an open meeting requirement, my preference as an attorney representing associations would be that you have your budget discussion and adopt the budget, the proposed budget, during a board meeting and have that decision reflected in the minutes of the board meeting. However, if the board chooses to vote via email, their decision to approve a proposed budget must be unanimous. So every single board member has to respond and vote to approve the proposed budget. And then my recommendation would be to ratify that decision at the next board meeting and record it in the minutes of that meeting. But best practices for sure is to do it at a meeting and not via email. Ken, did you want to take a different position or add anything to that?
No, it's the same as any other board decision which is made. It should be done with discussion at a meeting. The statutes allow for unanimous written consent by the board members and then ratifying that action at the next board meeting and putting it in the minutes. So that's no different for the budget approval by the board than any other board action.
And, before we get too much further into the questions, I want to let everybody know that number one, if you don't want to listen to a bunch of random Q&A, you can leave now and we won't be offended. And number two, I can stay as long as we have questions. So I don't want anybody to worry that we're going to run out of time. I don't think we're close to that with the number of questions we have, but I just wanted to let everybody know that. So our next question is this. When we say current reserve study, does current mean only the current year? What if the reserve study is 2 years old? So current means the current year. And by statute, your association is required to have a reserve study every year. Every 3 years, you have to have a full or on-site reserve study where the reserve professional comes to your community and looks at all of your components so that they can look at the condition that they're in and estimate their remaining useful life. But in the 2 years in between those every 3-year on-site reserve studies, you also have to have a reserve study update. And that is essentially where someone, whether it's your reserve study professional or a board member, updates all of the numbers in the reserve study so that they're current as of this year. So if you have a 2-year-old reserve study and you haven't had an update done since that time, then you don't have a current reserve study. There are a few exceptions, communities that don't have to have reserve studies, but they're almost never applicable. One would be if your units are strictly for non-residential use. Another would be if the cost of the reserve study exceeds 10% of your annual budget. And then a third is if you are an association that only has nominal reserve expenses. And nominal would mean something like you have 0 common elements other than the sign on the way into your community, and that's your only financial obligation, is to maintain that sign. If you have things like parking lots or roads or retention ponds or other elements that you're required to maintain as an association, then you have more than just nominal reserve expenses. So if your reserve study is 2 years old, then it's not current. And I hope that answers the question. Ken, did you want to add anything to that?
I will offer that for some reason, a lot of reserve study professionals are doing studies in early or middle of one year and then calling it a study for the next year. So I had one just last week I was looking at. The study had been done in June of 2022, and yet they placed on the cover of it that it was the 2023 reserve study. I don't know why they're doing that. It makes no sense to me. I think it is okay if you do not have a current study to include the 2 paragraphs that we've already described. And then if you want to say, we had a reserve study 2 years ago and it showed that we were only 40% funded, or that we had a deficit of $400 per unit, or whatever the information is, you can certainly do that to help provide more information to your membership. But I would still respond that you do not have a current reserve study and therefore cannot comply with the statutory requirement.
I agree. All right, here's our next question. Does the outcome of the ratification meeting have to be mailed or can it be emailed? If your owners have opted in to receive notice electronically, you can email it to those owners. You need to send it to the rest of your owners by regular mail. So this would include, and because that's your official notification to the owners that the budget was ratified and next year their assessments are going to be X number of dollars per month or quarter or whatever. And you need to be able to document that you actually gave notice. And I'm using air quotes here because giving notice actually means something legally. And the way that you give notice in compliance with your governing documents and the statute is to send it by mail. Unless the owner has opted in to receiving electronic notice, then you can send it by email. You want to add anything to that one, Ken?
Well, I think if you're mailing out coupon books, which a lot of clients still do, that would qualify as giving notice.
Yeah.
If you're not using coupon books, then I think a specific notice is required, because that's what is confirming the date that the amount is due and the dollar amount that is due.
Yeah. All right, next question. If an association software has an election tab to vote for or against a budget, would that suffice as a proxy if the management assisted homeowners if they needed help to vote? This way, the vote is documented with the homeowner's account, so there is less chance of fraudulent proxies. As a starting point, what I'm going to say is that we generally don't recommend to our clients that they include a proxy or a ballot for the budget ratification meeting. And this is another reason why a lot of our clients are starting to hold the budget ratification meeting separate from their annual meeting. Because often when you hold them together, you are sending out proxies and ballots for things that you're going to vote on at the annual meeting. Sending a proxy or a ballot with respect to a budget ratification meeting, as Ken mentioned earlier, kind of gives your owners the idea of voting against the budget if they weren't already thinking about it, and it makes it easier for them to reject the budget. I don't think that you can limit your owners to using an election tab in your management software, even if we're talking about some other meeting for which you would be sending a proxy. A proxy, in order to be valid, just has to comply with the statutory requirements. And I think those, Ken, you can correct me if I'm wrong, but they have to be written by the owner, signed or executed by the owner. They have to be dated. And if there's not an expiration date on them, they expire, what is it, 11 months from the date that they're issued?
Yes.
Yeah. So if an owner shows up to a budget ratification meeting and they have proxies from 3 of their neighbors, and the neighbors are written on, the proxies are sheets of paper and the neighbors have clearly identified who they are, they're signed, they're dated, and they gave that person their proxy for the budget ratification meeting, I don't think you can refuse to honor those because they weren't done in the association's election software. Ken, did you want to add anything to that?
Well, I'll add that as much as I have some management companies and a couple of boards that really believe that the electronic voting is the way to go, I've got more clients where the potential for fraud and the potential that owners do not get to vote because of the electronic format is going to cause problems. I've got at least 2 clients right now that have been in litigation over the use of electronic voting. In one of them, it was because it was not doing it based on the percentages each unit had. In another one, it was because an owner couldn't get into the website for the Zoom meeting, and he filed a lawsuit claiming that the vote's invalid, even though I think 52 of the 60 homes did vote successfully. So there's no way he could actually change the outcome with his vote, but he's still in court right now challenging the electronic voting. So until the electronic voting has matured more, I am not a fan of it in any community where there is the potential that a group of owners is going to contest the results.
I agree. All right, here's our next question. If proxies aren't required, what happens when someone can't attend but wants to vote? Just because a proxy isn't required doesn't mean that it's prohibited. So if you have an owner that contacts you and says, I can't come to the budget ratification meeting, but I want to give you my proxy, or I want to give my neighbor my proxy, how do I do that? You can either, I suppose, email them a copy of a proxy form or tell them that they can write their own proxy as long as it's, written on paper, dated, identifies who they are, and they signed it. So just because they're not required doesn't mean that they are prohibited or that you can reject them or refuse to honor a proxy. Did you want to add anything to that, Ken?
No, I'm good.
Okay. Here's our next one. Can you vote to reject even if no motion was made? Or was that the accept reject? Is that what the accept reject was for, i.e. the motion? So a motion is just something, it's parliamentary procedure, and all of our association and board meetings are supposed to be run at least loosely in the manner of or following parliamentary procedure. So what this looks like is that any owner who is there and wants to reject the budget at the end of the discussion period, when the management company or the board says something about whether it's time to vote, any owner can just pipe up from the floor of the meeting and say, I make a motion to reject the budget. And then somebody else seconds the motion and then the vote happens. Some associations are just skipping that whole part. And at the end of the discussion and the presentation about the budget, the board is just calling for a vote whether to accept or reject the budget. So I think the vote is valid even if there is no motion. It's just that's a more sort of formal way of doing it. Do you disagree with that, Ken?
No, I think that's okay. There's not, I'd say, an absolute right or wrong on this. I've been at meetings where we have explained to the membership that at least 50% of the voting power has to reject it, and that if they don't think that there's going to be 50%, there's no point in calling the vote.
Yep.
And I was at one meeting at a 225 member community. They had well over 100 people in attendance. And after we explained the process, we just asked if anyone wanted to make a motion to reject. No one wanted to make the motion. because they either knew they couldn't win that motion, or they just didn't want to take the time for 100+ people to do a roll call vote. And we adjourned the meeting 2 minutes later. So.
Thanks, Ken. All right, here's our next question. In a condo association with 100 units, 99 opted into electronic notice and 1 did not. The notice was only sent out electronically. Is the failure to send via snail mail to one owner significant in the ratification process? Well, I mean, I suppose it depends on how you define significant, but if that one owner who did not get notice of the ratification meeting decides to challenge the budget for failure to give proper notice, then they will likely prevail. And so the low risk thing to do, in particular, if you think that owner is likely to challenge this action, is to hold a new ratification meeting and re-ratify the budget. It could be that nobody ever says anything about it and that it's completely fine. And without the ability to predict the future, I left my my crystal ball in Vegas last time I was there. Without the ability to predict that, it's hard to know how significant this is, but it is a procedural defect in your process. Did you want to add anything to that, Ken?
If it was one of the owners who did receive electronic notice, I don't think that they could successfully challenge the failure to mail to the one person who required postal service. So it really depends on who's doing the challenging. The owner who did not get notice could successfully challenge it. Owners who did receive notice properly would have a much more difficult time. But if you change the ratio, instead of 99 versus 1, and it was 75 owners got electronic notice, and you failed to notice the 25 other owners, then I think you're going to have a problem. And if it's 50-50, for sure you've got a problem.
Yeah.
But it does start to become fact specific.
I was just going to say that it's inconvenient to have 100 units even in the community. I hope they have different percentage allocations for voting purposes. Somebody asked for me to repeat the email address to send a copy of the presentation. It's info@condolaw.net. I also put that into the chat, but just in case somebody is on the phone and asking the question, it's info@condolaw.net. Also, we do Wednesday morning Q&As for those of you who don't already know that. If you want to participate in those and be on our general email list, we typically only email about things like this. You can also ask to be added to the email list if you're not already on that by sending an email to that same email address. Next question, can 2 budgets be ratified at the same meeting? For example, one from a previous year if it was not properly ratified and one from the current year. Yes, you can ratify more than one budget at the same meeting. We often have clients that will be ratifying the next year's annual budget, but also ratifying a special assessment at the same time. And we have had clients also successfully re-ratify to fix issues with prior ratifications and then ratify a new budget at the same time. Did you have any comments on that?
We also have some clients that have sub-associations. So they will combine the master association's budget and a ratification of the sub-association's budget into the same meeting.
Yeah. Okay, what happens if an HOA decides to spend money on operating expenses that were not budgeted for? Nothing happens. I mean, unless somebody, vocally disagrees with that change during the middle of the year and decides to, file a lawsuit over it. But a budget is just a spending plan. And just like our personal spending plans, if we have our tire blows out or our sink leaks and we have to divert money from the Christmas present fund to the plumbing fund, the same thing can happen. Things change throughout the year. The cost of certain services might increase, or there might be, repair emergencies that an association has to pay for. The board has the discretion to vary actual spending from what the budget calls for. Obviously, in particular, if it's a reasonable variation. There's no risk in doing that, except for, owners might get mad about it and make a stink. But what the owners are ratifying, and I think this is a really important thing that Ken mentioned earlier, so I'm going to repeat it. What the owners are ratifying is the amount of the assessments that they're paying. That's what they're ratifying in ratifying the budget, right? They're not their vote doesn't mean that they then get to control every dollar that is spent when your year actually happens versus what the plan was. So the board has the authority to spend the association's money how it sees fit, as long as it's reasonable to do so, and even when that varies from the budget. Did you want to add anything to that, Ken?
The only exception is you cannot spend money out of your reserve account
Yes.
for expenditures not associated with reserve components unless you follow the requirements of the statute. And that requires that you give notice of the expenditure to your membership, and unless it would cause an undue hardship, have a plan for restoring those reserve funds over the next 24 months.
Agreed.
Otherwise, it's been to court in Washington State where an association was spending money very differently than the budget had planned for because they had different circumstances come up. And if you've got something like a large uninsured loss for your building or a major repair, you're suddenly replacing plumbing lines under the buildings, then you will see significant changes. If you are having enough of a change that you need to do a special assessment, then just do a special assessment to get you back on track.
Thanks, Ken. Okay, our next question is, requiring an absolute majority of all owners to reject a budget, but anything less than that to approve it, seems fundamentally undemocratic. Can you speculate why the legislature established that approach so we can explain it to our members? I'll offer as a starting point that associations are not democracies. I mean, they're not pure democracies, right? Just the same way the United States is not a pure democracy, we're a representative democracy. But that's probably not really responsive to the question. And I think the reason the legislature made this change is because it recognized how difficult it is to get owners to vote on anything half the time, way more than half the time. And anybody here who's tried to pass a declaration amendment in their community and has sort of beaten their head against the brick wall of apathy that most of our communities face understands how difficult it is or was to get a budget approved when 50% or 67% or 80% of the ownership had to approve that budget in order for the assessments to be increased. So I think that's part of it. And I also think part of it was the legislature recognizing that when you purchase a property in a community association, you understand that you're buying into a community where there is an elected board that is required to act in the best interest of the association. And the board is the best equipped to determine what a reasonable budget is to accomplish the association's goals, to adequately fund the reserves, to keep up with the increasing cost of goods and services based on inflation, et cetera. And so I think it made more sense. And I think from the perspective of a vendor who works with community associations, it makes more sense for the default to be that the budget's ratified, but still leave the door open for the ownership to reject it if the need arises, versus the default to be that it's next to impossible to increase the assessments or to get a budget passed because you require a certain percentage to vote for it in order to make that happen. Ken, did you want to add any other comments on that?
Well, I just would add that this did give much more power to the membership for old act condominiums, because they are a group that never had to do a ratification of their budgets before Ukiah was adopted. And so homeowners associations since 1995, condominiums created after 1990, they did have this ability for the membership to rise up and vote down a budget. But the older condominiums, there was no power for the community. Whatever the board wanted to do was just absolutely done. Yeah.
All right, I just want to recognize that it's 6:59. So again, if anybody needs to go, you're welcome to dip out when you need to do that. We do have a couple more questions in the chat, so I'm going to move on with those. If you do have the homeowners association meeting followed immediately by the budget ratification meeting, does one proxy cover both events? And I think it depends on what the proxy says. If the proxy says it's for the budget ratification meeting, it only works for that. If the proxy says it's for voting on the amendment or just for the purposes of the annual meeting, and you've made it very clear that these are two distinct meetings, then maybe it only covers the annual meeting. On the other hand, if the owner has written a very general proxy that says, I give my neighbor Bob Smith the right to vote on my behalf regarding association business, then a more general proxy like that probably would cover both events. Ken, did you want to add anything to that?
I would generally lean in favor of recognizing the proxy for both, because I don't think it's going to make a difference ultimately for whether the budget's rejected or accepted. And I'd like to avoid the conspiracy theorists coming out of the woodwork and claiming that the board has been rejecting votes improperly, because that's another thing which I've had happening the last month, is a claim by individual owners that the board improperly rejected proxies at a meeting, and that's the only reason that the budget was not rejected. It's one where 75% of the people who showed up for the meeting rejected the budget. So the people in attendance were resoundingly opposed, but they only represented 45% of the total voting power. And so the budget was, our special assessment was approved. But they're claiming that the board members and management manipulated the counting and the proxies and the ballots in order to get the number that was rejecting it under the 50% threshold.
Yeah. I think the other thing to keep in mind, again, what I keep hearkening back to is the fact that you have to have a quorum for your annual meeting in order to do any business, and you do not have to have a quorum for the budget ratification meeting. So even if you have them on the same night, I would strongly recommend that you make it really clear in the notices that these are two separate meetings, and perhaps hold the ratification meeting first so that you give stragglers a chance to get there in time for the annual meeting and maybe give you a better hope of achieving a quorum. I know that's not really specifically relevant to the proxy issue here, but I think for ease of sort of keeping your procedures straight, it does make a lot of sense to hold the meeting separately, especially because ratification meetings, unless there is a lot of dissent in the community and a high likelihood of rejection, they tend to go pretty quickly in a community where they end up being ratified. All right, next question. I just held a ratification meeting where the membership had 30 days to reject the special assessment via ballot, whether by email or paper ballot. Should we have allowed an in-person vote as well during the meeting? Absolutely, yes. People who did not submit a ballot ahead of time should have been given the opportunity to vote at the meeting. I don't love the idea of letting people have 30 days to reject it. I guess because I think as a practical matter, again, why are you working so hard to make it easy for your ownership to reject your budget if you want it to get passed? So that being said, I don't know that allowing people to vote ahead of time is a bad idea or is invalid, but I think not allowing people to vote at the meeting does make your procedure flawed and problematic. Ken, did you want to add anything on that?
Valerie, that they were talking about giving people 30 days after the meeting to vote.
No, it says the membership had 30 days to reject. Oh, should we have allowed an in-person vote as well? So you're thinking the 30 days was after the meeting?
Right. And
okay.
I would still say
it probably doesn't matter. You should, yeah.
Yeah, I would still say give them an opportunity to vote at the meeting, even though you're giving them an opportunity to vote by ballot. I don't like the voting by ballot. I would rather that the votes all be done at the time of the meeting.
Yeah.
People who cannot attend can give their proxy to somebody else. But there is the statute which was adopted last year that says people can vote at meetings in person, by proxy, or by absentee ballot. The absentee ballot has to be provided by the association the way the statute's written. So if you wanted to allow people to vote by a paper or absentee ballot, you would need to provide them that ballot in the packet that you send out with the notice. I can't say it's wrong to do that. If your hope is that you'll get more participation to show their support for the budget, then sure, you can do that. But it's not the sort of thing where I would encourage people to continue to collect votes for 11 months, which would also be required under that particular statute, in order to get enough votes to reject the budget. You're looking for a time certain where you can say a majority did not reject it, so it's good. And I would rather you just make that date and time the meeting that you're calling for the ratification.
Yeah, and I'm just gonna, looking at the budget ratification section of WCIOA, it says, unless at that meeting, the unit owners of which, or to which a majority of the votes in the association are allocated, or any larger percentage specified, in the declaration, vote to reject the budget, then it's ratified. So I think that there's actually a fairly convincing argument to be made that the statute requires the voting to happen at the meeting, and that allowing voting 30 days before or 30 days after at least raises a question of whether you're complying with the statute. So I think don't work so hard to make it easy for people to reject your budget, and do the voting at the meeting. That's just my personal preference. And I think with that, we are at the end of the questions. So you guys are very timely because we're only a few minutes past. Thank you all so much for joining us tonight. If you do have additional questions, send an email to info@condolaw.net and start coming to our Wednesday morning Q&As, and we will try to answer them then. It's good to see everybody. Thank you. Bye.
Thank you.